What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hopefully you guys are having a great day so far. Oh, I've got a good one. This guy brings a lot of attitude in front of Judge Goggins. Judge Goggins is out of Michigan, and he rarely ever loses his cool. Judge Goggins, that is. This is no exception. He handles this beautifully. Well, besides not holding this guy in contempt, which he probably should. Okay, before I hit that play button, you know what to do. Hit the like and subscribe. Do your chop kick backflips. Let's go.
Your Honor.
Okay, Mr. Berlanga?
I am ready on the Lee motions, Your Honor.
Okay, Mr. Blanchard, does that take care of it for you?
It does, Your Honor. Thank you.
Okay, I'll make a note and I'll just sign the subpoena for you. And I guess on that one, Jan, I guess I need another pretrial date, I guess.
24th.
So that one, and Mr. Berlanga will get you back here, and I guess I probably gotta get Mr. Lee. Did he make his way back?
I told him to leave the breakout room. I'm not sure if he's back in or not.
Okay.
I'm here, but my camera won't join on the laptop, and I'm trying
Okay.
to join with my phone so you can see me in person.
You know what, Mr. Lee, you're coming in good like you are. Let's just leave it like it is. When we start around, I might miss you. Okay.
Yeah, yes, sir. There's just some stuff I actually needed to show on camera for you to actually see, and I could do it on my phone.
Mr. Berlanga, I guess I gotta look at what's our motion here. Posting messages. This.
Your Honor, I haven't been able to review any of the documents that he has. He resides in Florida, and I've only been able to talk to him with no camera.
Okay, Mr. Lee, I guess I'm not gonna allow, if you've got being represented by an attorney I don't want to put him in a spot where he doesn't know what's going on. And I want you presenting something he may not want me to see.
It's all I was going to present was a document stating January 7th, 2024 of my Eagles Nest 4526 Eagles Nest Road, Fruitland Park, Florida. I wanted to show that my address was known, and they sent my notice to appear to an address that I have not lived at for a very long time. And it's even documented with the law enforcement down here that they know I didn't live at that address.
Is this, I guess I'm looking through, I've got like
a lot.
Significant amount of documents. Is it, Mr. Berlanga, maybe you can help me. Is it his motion?
Your Honor, I can condense this for us.
Sure.
There are about 3 to 4 motions. One of them, and the one that I think are, have a basis, a motion to amend bond. I have a motion for permission to appear by Zoom for a trial date. And then there's a constitutional challenge to the Burton City Ordinance that he's being charged under. And then there is a civil rights violation that Mr. Lee, I can only make brief objection for the record, but I would have to defer to Mr. Lee as far as anything else.
All right, so there we go. Those are his motions. So he is pro se. He has an attorney. It's a giant mess. He wants an attorney for one part of the trial or one part of this hearing, and that's absolutely it. So you'll hear about it. Judge Goggins does not put up with it anyways. Civil rights violation. Okay. Can't wait to hear that one. And then a constitutional violation. Where do you hear these things? generally from subsets. This guy's not a subset. At least he doesn't go through the script. But yeah, he's a wild pro se, that's for sure.
And I'm not going to have a hybrid where you're representing him something and, he's
Understood, Your Honor.
on his own. I'm just not going to do that, quite frankly. Miss Odette, did you receive copies of, I guess it looks like 1, 2.
Your Honor, I receive a copy of something from him daily. So I'm sure there's some motions. There's a motion for religious beliefs. There's a motion for First Amendment. There's a motion to charge the victim. There was a motion. There's several motions.
Okay. I guess Mr. Berlanga.
Your Honor, with regards to the other motions, I only have the 4 that I mentioned. Mr. Lee did make mention today to me that he is considering representing himself pro se, and I don't know if that was representation that he did not want my assistance today. For the record, I would like Mr. Lee to make his intentions known to the court as well.
Okay, so let's start out with that first of all. Mr. Lee, do you want a court-appointed attorney?
No, sir. I just want assistance of counsel
But no, you
to
can't
help
have,
with
hold on, you're not going to have,
subpoenas.
just an assistant. It's either you want an attorney or you don't want an attorney. That's what we're going to do.
I do not want an attorney, but I do want him to represent me on modifying the bond conditions, and then I would like him to withdraw after that, and after you make your ruling on that, and for me to represent myself after that, because he is not going to challenge the city ordinance that I've been challenged with, and I have it documented on this case file in front of you.
Sir, let me ask you this. Are you working
Yes, sir.
right now? Do you have a source of income?
Yes, sir. I work at Olive Garden at 9 in the morning. I get off sometimes 12, 1, 2, or 3, and then I work at Gators Dockside in the Villages. I work every single day. I can't afford.
Well, how much do
down
you take home on a regular basis? You get paid weekly or bi-weekly?
At Olive Garden, I get paid weekly.
Okay, how much?
And like 150 to 200.
Okay.
I only work like a couple hours each.
Okay.
And Gators Dockside every 2 weeks, I bring in a 1,000, sometimes a little under and sometimes a little over. So you could just say 1,000 every 2 weeks. You could say $700 every 2 weeks with everything. I mean, every week with everything combined.
Okay, so in average $700 bi-weekly every 2 weeks.
No. Olive Garden, I get paid weekly. Gators bi-weekly.
I know it, but
weekly.
All right, I don't know how people mess this up. Not every single time. Some people understand the question, but this isn't a difficult question. You work, and apparently you work a lot. You know how much money you make. That's all he's trying to figure out. If he can approve you for a court-appointed attorney, that is all he's trying to figure out. Just tell him how much you make a week, or tell him how much you make a month. That's all you need. We don't need all these stories.
Say 700. I probably bring 2,000 something plus dollars a month. My math is all off right now. I'm
so
sorry.
about 700 per week. Is that right?
Yes.
Okay.
Yes.
Mr. Berlanga, I don't know what you're.
I would have to double check. It sounds like he's pulling in about $2,800 a month. He has dependents, Your Honor.
Okay.
I would. Have to do the math to determine if he could actually qualify for court-appointed counsel.
Yeah.
Regardless, Your Honor, it still sounds like Mr. Lee does not want court-appointed counsel assigned to him, only for argument of one motion, and then he would want me to withdraw. I don't know if Your Honor would like that to be the case, or if he just wants to represent himself.
Is it just the motion to amend the bond?
Yes, that's the only thing he wanted my assistance with.
Mr. Lee, is that true? Is that all you want the attorney for?
Yes, sir. So I have a better chance of seeing my kids, you know, just to modify it where I can see my kids because the mother's present. And if you would allow him to argue that, and then I could
Well, and you got,
represent myself on the other stuff.
if I do that on that limited basis, that's it for him. I'm not gonna bounce between having an attorney, not having an attorney.
I understand that. They have the same
Okay,
thing in
I
Florida.
just wanna, okay, I just wanna make sure because that's all he would do. It's just that one bond amendment motion. And then the
Yes, sir.
rest you're on your own. And
Yes,
that,
sir.
and I'm not gonna flip flop back and forth, right? Today, you're gonna waive your rights to an attorney after that, it sounds like. Do you understand?
Yes, sir, I do.
Okay. Ms. Otat, I know you're being awful quiet. Can we do the motion to amend bond and then the others will, I guess I'll figure out what we're gonna do.
And
Yeah, that would be fine, Your Honor. Yes, I would object to any amendment of bond. Now, with regard to the other motions, would it make sense to set the jury trial date, hear all of it all at once, to get Mr. Lee up
Yep.
here and done all at once? That would just make sense, I
Yes.
think, for everyone.
Yeah, in fact,
I would object to that. In the bond conditions currently, it says I can reside in the state of Florida.
okay, well, that's what I'm gonna deal with right now, though. Let's just deal with the bond motion amendment, and then we'll deal with the rest of it, okay?
Thank you.
That's all we're gonna do. So, Mr. Berlanga, I'll let you, are you ready to do that?
I am, Judge. Yes, I can do that right now.
Okay, all right, let's do that one, and then I'll figure out what to do beyond that.
All right, Your Honor. It's defendant's motion on behalf of Mr. Lee to motion to amend bond. Right now, there's a bond condition in place. It's a no contact order with a Jessica Locke, I believe is her first name, but Miss Locke is her name. The complaining witness on this case, they have a child in common. There is a court order in the state of Florida regarding parenting time. Mr. Lee receives parenting time by video with his child at least once a week, pursuant to the order. With the no contact order in place, he has not been able to see his child on a regular basis. In fact, the child resides with the mother here in the state of Michigan. Therefore, it makes it difficult for them to arrange any kind of contact to have parenting time take place. Mr. Lee, he wants to see his child, and as far as this case goes, Your Honor, there are accusations at this point. He has been charged formally. However, as far as the basis of the charge and everything that comes in this case, there's a lot of, let's say, I don't know the right word to say it. It's a contentious case, but I'm not saying it's meritless, but there's a lot of accusations that are tenuous at best. When it comes to this case in my, analysis. On behalf of Mr. Lee, I think it is important that he be able to see his child at least through video message. And that would be, he's just asking for a no violent contact, or there's a no assaultive contact with the complaining witness in this case. She does reside in Florida. He resides in Florida. She resides in Michigan. I don't see the harm in allowing him to at least see his child by Zoom pursuant to the Florida court order that they have.
All right. So, I mean, at least this is, the right motion to make. You want to be able to video your kid. And yeah, I mean, that makes sense. But if you don't get along with the mom and you have to go through her to video your child, there's a lot of nastiness that can happen on video. It's not the same as just jumping on the phone and where she can, I guess she can hang up on you. But yeah, this guy has to be in a lot of trouble. And he's had to have done some and said some pretty dumb things to not be able to video his kid on a normal basis. Man. Also, this is a slow start. I know it's kind of boring right now, but it's about to get really good. I guess I can say it's about to go down.
Have in place through their custody case. That is all I have, Judge. I'd ask for the court to have a no assaultive contact with Miss Locke so that they can continue, that Mr. Lee can see his child.
Okay, I guess, Ms. Odette, why don't I have you just respond to that? And I may have a couple questions anyways, but.
Just briefly, Your Honor, that's where these charges stem from, is his alleged attempts to make contact with his children. He is harassed. He is threatened. That is what he does when he gets on Zoom with this victim. He has called, the police report indicates he has called the Burton Police Department over 19 times in the span of a few months, threatening to report welfare checks, to intimidate her, to threaten her. He is, as you know, Judge Hammond was disqualified because he was continuously emailing and threatening both her court recorder and her. I myself had to have a sergeant tell him not to contact me via email or phone any longer because of his constant threats, harassment via text, via email. So clearly this is his MO. And I do not think that having a no assaultive contact order and letting him see essentially this victim via Zoom for these, and I understand he needs to see, he should see his child, but at this time I would ask that you deny that bond modification.
Object.
All right, I paused it right when Mr. Lee is saying objection, but there you go. Yeah, that's why you can't do it. He's earned that. Emailing the judge? What is he doing? Not a very good pro se.
Action.
Mr. Berlanga, with regard to, help me out with, I'm not sure how him having no contact with hers, he can't work out some arrangement that he has contact with his, I guess, his children.
Your Honor, it is a Zoom contact, so they are residing in separate states. The child only lives with her mother, so as far as setting up any contact, it would have to be with the mother in order to try and arrange for a parenting time visit. I don't foresee any other, path as far as trying. I believe the child is an age that I don't think she would be able to set up the Zoom herself.
Because I'm not gonna order that he can't see his children. I mean, over, whatever the court order down there is. And I'm guessing, is it a family court of some sort?
Yeah, my understanding, Judge, and I think he attached a copy of maybe one of the judgments that was signed by a Florida judge.
Yeah.
From my review, is that it is a Florida family case.
Okay.
And I
So,
think he attached it to one of his amendments for bond motions.
okay. So the motion to amend bond is denied. No contact with Jessica Locke, period. The charging instrument does state that that the concern is posting of messages causing the victim to suffer emotional distress, and goes on from there: intimidating, frightening, terrorizing, harassing, molesting her is alleged. Quite frankly, there's all other kinds of ways to get around him having contact with his children, but that's a family court matter. That's not for this court. They can order her to be, they can order something else down there, but no contact with her. So,
Yep. Your Honor, I would like to object to this.
okay, you did.
May I state for one quick reason? I am prohibited from filing stuff in the family case in Florida unless I pay $10,000. And after I pay $10,000, I can't request no relief. She was court ordered to open up a PO box where I can mail my children gifts,
Okay.
Your Honor. She hasn't done that. She's given me false addresses. She's supposed to host the Zooms at 11 a.m. on Saturday morning. She's supposed to be present. She's supposed to record it. I'm supposed to record it.
Okay.
And she is manipulating the criminal courts for me not to see my children. And she's also has violated Burton 138.03 by sending me emails past the 11 o'clock deadline when I text her and I told her in Zoom before the no contact order was entered in this criminal case for her to stop that. So, Your Honor,
All right, Mr. Lee,
This
made-
all sounds
so
like,
a
Mr.
victim of her doing it. And
Mr. Lee, those sound like they're all issues for the court down there to deal with your children. So,
Mr.
No,
Lee, you
it
made your
is-
record. So judge has made his decision. He's made his ruling.
Okay,
You
so
made
that's-
your record.
and from that point, I think what we need to do, quite frankly, I'm not going to allow, in fact, court rules don't really allow it for this is set for, I'm sorry, Mr. Berlin, is it set for a jury trial? Was that what it is?
Your Honor, I don't know if there's a jury trial set right now. I think
Yeah, but I think that's what's in order. It looks like that it's automatic set for a jury trial. So we'll leave it on for a jury trial date that I can't have it by Zoom, unfortunately, Mr. Lee. Do you have to appear in person? Leave on for trial. When do you want this? Do you want me to set it for sooner than later, or do you want it set for like September or October, sometime in there?
I mean, Your Honor, I want to see my.
All right, I'm going to let this video play out. I am going to warn you, I don't have the last 5 seconds of this video. I didn't want to say that at the beginning. Judge Goggins hangs up on this guy, and apparently when I was editing the video, I cut off right when he hung up on him. But he hangs up on him, and then they just move on to the next case. They already have the date set. Everything's ready to go. But, yeah. He hangs up on him before he gets contempt. But you'll see. You'll see exactly when it happens. All right. I'll see you guys later. Until next time. Bye.
Kids, I want another hearing to modify.
We'll have any motions I'll hear on the date of trial. I gotta be here.
I need
Mr.
the
Lee,
other motions heard to modify.
Mr. Lee, we're not gonna do it. We're not gonna do that.
That's what you
leave it on for a
agreed
jury
to.
trial. I'm gonna leave it on for a jury trial.
Amanda Odette and Jeff Child said on the record last time we were here, I posted it on YouTube. She said she didn't receive any of my motions. It's posted on YouTube. It's documented that she did with the United States Postal Service.
Okay.
She gave false information to the court. She committed perjury. She had Jeff Childs lie for her. And then I'm getting ramroded by getting this dude who works with Jeff Child.
Okay,
And
so
I have documents that I need to show on video.
No, I'm not going to do it on video. We're going to do it in person. Leave on for jury trial. Miss
You're
Odette.
not letting me hear the other motions. I don't want an attorney. You're forcing an attorney on me.
No, I'm not.
I want to argue the
Let's set it for September. Let's set it for September. Yeah.
I object. You're violating my rights.
What's their date in September?
Motion.
September 12th.
Constitutional challenge against Burton City Ordinance 138.03. Unlawful posting.